Hello, everybody. Mentor Lawyer. We're here to discuss the case of State of Florida versus Sarah Boone. It concerns the 2020 death of her boyfriend, Jorge Torres. She calls him George. I call him Jorge because that's the way you say George in Spanish. And I met with Sarah Boone 3 times last week. The first time just to introduce myself and see whether she wanted to talk to me. And then when she agreed, we had 2 meetings. Those 2 meetings were protected by attorney-client privilege. I will not be representing her in her case, and that was agreed upon up front, but I did meet her twice, and both were set as attorney-client meetings with the full permission of the jail. Because of the fact that those were attorney-client meetings, per the agreement that I had with Sarah Boone, I agreed and I will protect the attorney-client privilege as to our communications. There was a limited exception that we both agreed to, and I'm going to read what I wrote first, a little summary of what I could do that she and I both signed at the conclusion of the meeting. And I'll tell you then a little bit about what we agreed that I could discuss here on the channel. And it's going to have to do primarily with the difficulties that she faces now that she's representing herself, and with the fact that she does want to have a lawyer represent her. She does not want to represent herself at trial. This is a very serious case, and she would love to have an attorney on her side presenting the case. So here's what we wrote that I could say, and then I'll just talk a little bit. But I'm not going to discuss, so if you're here to discuss details, her explanations, excuses, whatever, I'm not going to discuss any of our communications about the issues in the case or about anything that we may have discussed, right? I'm only going to discuss what's in this letter. Now, our agreement also says I've covered this case. I was actually the first channel that covered the case way back when, maybe 2 years ago or so. And the agreement is I'm going to continue to cover the case. Our channel will continue to cover the case. And so I can obviously speak to the evidence that we have all seen. I'm just not going to share anything of what I learned directly from her as far as those issues go, if anything, right? So here's what we wrote. So Mr. Rachevsky is allowed to discuss on his media channels the fact that he met with Sarah Boone on July 29, 30, and 31, that he showed a little bit of the evidence in the case to her, because as you all know, obviously I have all the raw materials that were provided in public records disclosures after those records became available in discovery to the defense. We were able to get copies. So I was able to show a little bit of the evidence. Obviously, there's limited time that we got to meet, so I only was able to show some of the evidence that she had never seen, but we didn't have time to show a lot of it. And so I showed some of the evidence. We also discussed the difficulties that she had with her former attorneys and now with representing herself. And I'll tell you why I wanted to meet with her, because one of the things I do in this channel is I cover the justice system. I am a former prosecutor. I am a former criminal defense attorney in the sense that for a little bit of time, because I'm not a criminal defense attorney now. I've actually retired from doing any criminal law cases maybe 2 years ago. So I did it only for about 2 years as a criminal defense attorney. I was doing all of it as a conflicts attorney through the Judicial Administration Commission, where the court would appoint me, sort of like Sarah Boone got appointed lawyers after the public defender withdrew for a conflict of interest, and after the Office of Regional Conflict Counsel withdrew for a conflict of interest. What the courts do in a case of somebody who cannot afford to hire their own lawyer is that there's a conflicts list, a list of attorneys who are qualified to do the particular type of work of defending somebody who's accused of a crime. And it depends on your level of experience and qualifications about whether you're going to be listed for second-degree felonies, first-degree felonies, capital felonies, or just misdemeanors. You can also, as the attorney, decide that you're only going to take misdemeanor cases. So I did serve as an attorney for a couple of years, doing only those cases where I was appointed by the court as a criminal defense attorney. So I'm familiar with how the system works. And so we discussed that. So my interest was to understand, like, did she want to represent herself? Does she want to have an attorney? Why were all those problems coming up? And was it fair that the court decided that there would be no more attorneys appointed for her? I have obviously deep respect for the court, but I sometimes disagree with a decision from a judge. Now, in this particular case, I had some concerns when this whole thing happened. I thought there should have been maybe a more full evidentiary hearing with a better understanding from the judge. Is she just creating trouble to cause delay? Are there legitimate concerns here? Maybe there should have been something more, in my opinion, before going to such a drastic decision as to preclude her from having any lawyers. So I wanted to meet with her to discuss those issues, and if she would allow me to talk about them, I would. And so in a sense, I am allowed to discuss the issue of the fact that she still wants to be represented, that she still wants to have a lawyer, and that she hopes that somebody will do that, will take the case. Because if the court's not going to appoint anybody, then the only chances, the only choice that she has, because she doesn't have money, is if somebody will agree to represent her. Now, I'm not going to represent her. I'm going to clarify that again. I'm not going to represent her. I'm retired from doing criminal cases, so I will not be representing her. But the letter continues. Our meetings and discussions were protected by the attorney-client privilege, and I won't be talking about our discussions with Ms. Boone except for what she asked me to discuss here on the channel, because Ms. Boone does not want to represent herself. She wants the help and guidance of a good attorney who has the time and the resources and the interest in getting involved in this type of case. This is a one-of-a-kind case, of course. I think we have seen situations. Let me back up for a second. All right. So I have actually looked at all of the evidence that has been made publicly available. So right now I'm getting off my conversation or my meetings with Sarah Boone. I'm going to tell you my impressions in the past about this case, right? This case involves a situation where there's a couple that was living in an apartment together. They were not married. They definitely had issues with consumption of alcohol. There are issues in the apartment about prior abuse. There's testimony from a neighbor saying that Sarah Boone occasionally would, she slept on their porch outside, that occasionally she would come over scared. And we have seen her interrogation, and she does raise that issue as well. She talks about issues of prior abuse and talks about the fact that they were working on those things. And there's also, to be fair, there's also some evidence of potentially she also being abusive. At least there was an accusation towards her from George, and I think that those cases were all dropped in the end. And so I think we never got to find out who did what to whom. But domestic violence is going to be an issue in this case. So if there's an attorney out there who's looking to take on a case that will likely go to trial, unless there's a resolution, it will go to trial, and it will probably go to trial soon. And if you have interests on the issue of domestic violence, maybe that's a good case for you to take. Now, there's a ton of case law, a ton of legal articles discussing how domestic violence relates or plays a role in criminal cases. And there are two different ways that it has historically played a role. There are cases that talk about where the prosecutor is trying to bring expert testimony, usually in the form of expert testimony, make arguments to the jury to excuse the actions of a victim who has been a long-term victim of domestic violence, as an explanation perhaps of what was going on in the relationship. So in that particular case, it will be the prosecutor introducing evidence about something that the victim may have done, and explaining that to the jury to make them understand that they still shouldn't have been a victim. For example, staying in a relationship where they're abused and continuing to stay there. So that doesn't give perhaps consent to the person who's committing the domestic violence to continue doing that. So there's a lot of articles and case law discussing that issue, whereas the domestic violence becomes important as trying to explain away something that the victim may have done. And then there's the very narrow cases, but they're all over the country that talk about the spousal abuse syndrome or the partner abuse syndrome. There are different variations of terms of how this is called. But that usually has to do with the situation where the abuse victim will say, hey, let's say I killed or I tried to kill my spouse, my boyfriend, my girlfriend, the abusive person because I was scared, right? So a self-defense type of argument. Now here, this is a totally different case because from the evidence and from what we have seen in the interrogation, right? I'm not discussing anything about what I talked to Ms. Boone about in person, but just from an interrogation itself, we saw that she was kind of acknowledging that she was keeping George in the suitcase longer than he wanted to be there, but at the same time, she kept repeating nonstop the fact that she never intended for him to die. So this has different fact patterns than the usual case where that issue will be brought as a defense. So let me finish the letter. So she wants to have an attorney that will be able to obviously devote the resources and the time to sit down with her, go through the issues, go through the evidence, go through what happened and see if there is any potential defenses, and then explore those defenses. And even if it is not a run-of-the-mill type of case, but it is more a one-of-a-kind type of case, they will try to at least formulate a defense that makes sense and that goes along with those cases that have addressed the issue in more traditional ways. So Ms. Boone, in general, I can tell you that was pleasant. She was pretty reasonable. She allowed me to share my impressions. I told her my impression. And by the way, I wasn't there by myself. Ladybug was with me at the actual meetings where we had in person, where we arranged to have a computer so we could share some of the evidence. So Ladybug was there with me to help out, also to show the evidence and all that stuff and to take notes. So, and again, she was really hopeful that somebody will step up and represent her. And I did agree to come here on the show and do that and try to express that she would like to have a lawyer, that she is going to work with the attorney, is going to cooperate with the attorney, that she simply wants somebody who has the time to devote to a case that is not the run-of-the-mill type of case. And I do want to give you an explanation about how the system of justice works as far as the defense of those people accused of crimes in the state of Florida, right? So the first level of defense is usually for a defendant who is indigent. You have the public defender. And the good thing about the public defender is that they do have a lot of resources. The state of Florida does a good job in providing pretty good amount of resources for the public defender's office. And those attorneys are on salary. So maybe some of them are rookies. Just this, you're going to have the same on the prosecutor side as well. You're going to have a lot of people that are just starting at the public defender's office and just starting as prosecutors. Happens on both sides, but they have usually very good leadership, very good senior attorneys. So the public defenders usually do a pretty good job. And they have a lot of resources and time in their hand, right? They're not they don't need to rush. I mean, obviously they have huge caseloads and that could be a problem, but if there is a case that needs to have a lot of time devoted to it, they do usually have those resources to do that. The next level is the Office of Conflict Regional Counsel, which is pretty much the same thing as a public defender, but it is a different state agency. It is also supported by the state, so it's also lawyers paid for by the state on salary. And then the final level is the private attorneys on the conflict list. Now, the way that that works is that you get appointed a private attorney. A private attorney who may be very, very experienced or may not be very experienced. They would just have to meet a certain qualification that they're good enough to represent a person charged with a crime. And then you're going to be competing for those lawyers' attention against other clients who obviously potentially hire them in the private sector, right? So just to give you an example, I'm going to go back a few years ago when I was doing this conflict work. And I remember I agreed to take, it was a case, the one that I took to trial, okay? It was a felony case, felony battery case, and it was a third-degree felony under the law in the state of Florida. And in that particular case, my compensation for the entire case was $900. From the moment that I was appointed to the case until the end of the trial, until even after the trial, if I had lost, if I would have to file a motion for new trial or file a notice of appeal, all of that was $900. There are rare exceptions when you have an extremely complex case, and maybe this would have fit into that or not. I'm not sure. There are many situations where you could ask for additional compensation, but there's a lot of red tape, a lot of forms you got to fill out. The Judicial Administration Commission can object to it. So it's really difficult for an attorney who is in the private sector, who is doing this conflict work, to get compensated anymore over the flat fee. It does happen, but maybe some of those that are like professional attorneys that handle maybe like 30 or 40% of their cases is from the conflict list, and maybe they have done it for years. Maybe they have an easier way to get to that level where you get a little more money, but it's still limited money. And you're competing against the paying clients that may have paid, let's say, $25,000 to represent you in a DUI or $100,000 to represent you in a murder case. So that's what the court-appointed clients of a private attorney, right? So they have to take care of that client. They have ethical obligations to do a good job, to respond to their client, to do all those things. But you got to understand that where there is any room for discretion, where there is any room for you to, well, should I file this motion or not? If you're being paid a huge amount of money to do this kind of case, if it is a high-profile case and you're getting paid very well, you may have a little more of an incentive to do more. Obviously, every single lawyer should not do that, right? They should treat every client equally, but we're all humans. And I think that it's human nature that you're probably going to do a lot more if you're getting paid a ton of money, and you're going to be a lot more creative when you know that you're being fully and adequately compensated versus when you're barely getting paid at all, where it's like a joke. Obviously, if I would just devote that amount of time that I devoted on that felony case that I did for $900, where I got this guy not guilty verdict, if I devoted that to my paying clients, I would have equaled that in a very short amount of time, right? Maybe half a day at most, okay, depending on the client or the type of things I was doing. So that's how the system works, and it is basically a situation of luck, right? Which kind of lawyer do you get appointed? Is it a lawyer, for example, that really needs that money, or is it an attorney that, for example, like in my situation, right? I did it primarily not because I needed money, but because I wanted to do more trial work. Now, I would get appointed, and obviously I would do my job, the best job that I could for each particular client. And obviously I would exploit the possibility of a settlement in every one of those cases. Even though I wanted to do trial works, I wasn't trying to convince defendants to go to trial because I wanted trial experience. So I would just do the best I could. And then if the case went to trial, awesome, I would get trial experience. So we have ethical obligations as attorneys to do the best we can for every client that we accept. Is that enough to give every attorney that gets appointed by the court the incentive to do everything possible? I think that for the most part, the people that accept those type of cases, conflict cases, will do the best that they can. I do not know what happened and what broke down between Sarah Boone and those lawyers. Obviously, we had some discussions about that with Miss Boone, and just in general, what I agreed to share with you guys is this: is I think that she could be a reasonable client. She could be an attorney. I mean, she could be a client that can work with an attorney and and do what is necessary to get this case to trial. And I'm not saying that she should win, that she should be found not guilty or whatever, but I'm saying that she does have the desire and the capability of being a good client and of following the advice of a lawyer who has taken the time to go through the evidence and all of that with her. So I really hope that somebody will take the case. I do know a few young lawyers who who were my former law clerks and went to work, for example, for the public defender. So I will be myself checking with some of the younger lawyers that I know to see whether any of them are interested. But I did want to also to make this video so that if there's someone out there who's considering the possibility of taking the case because it is interesting, because there will be some publicity to it and stuff like that, I think that shouldn't be scared, and it shouldn't be like, oh, okay, this is going to be a crazy client. I thought that she was quite reasonable, and my personal opinion is that she could work well with a good attorney. So let me see what else did I agree to discuss. Anything else? Oh, I did want to say this. I want to make sure that everybody's aware of this. So I'm not going to give any interviews. So I didn't do this to seek publicity for myself. I did not do this. So I'm not planning to, and this is not something that she asked for. This is something that I told her. So I'm not going to be doing any interviews with any channels. I don't care who it is, big channel, small channel, TV. I'm not here to do any interviews about my interactions with Miss Boone. In fact, this is going to be the only video where I talk about that issue, and that's it. So don't send me emails, questions, or anything about Sarah Boone. I'm not a conduit. I'm not her spokesperson. I'm not, don't send me stuff to send to her. So this was simply a one-time thing where I wanted to do this interview, where I wanted to discuss the whole issue of her going to trial by herself without an attorney and the possibility of an attorney accepting the role. So this is really all that I'm going to be doing. I wanted to discuss those issues. That's it. Let me see, was there anything else I agreed to discuss? Yes, we did agree to discuss a little bit about the resources that she has. So obviously, for her, this is a huge undertaking now, right? To represent herself, to get herself ready for trial, a trial that has been set to happen in a couple of months, and which she has absolutely no experience as an attorney. So I did ask her a little bit about the resources that she has in the jail, and she allowed me to express the following. Number one, I actually saw it myself. I interacted with the jail personnel. She still doesn't have the computer. So she's supposed to get it on Monday, right? On Monday, she's supposed to get, not the computer. She's supposed to get the thumbnails, the thumb drives with all of her material, all the boxes of materials that the judge, with the help of the former defense attorney, Ms. Cashman, I think, they gather all these boxes. So the investigator in the case, who is paid by the Judicial Administration Commission, he was assigned to put all of those in thumb drives and then to bring it to Sarah Boone. So he's supposed to bring it. There's a hearing on Monday. So this investigator is supposed to go to the courthouse with the thumb drives. Sarah Boone is going to be there this Monday, and then the judge is going to be presiding over this hearing where the investigator is going to hand the thumb drives to Sarah Boone. She's supposed to have access to a laptop in the jail, apparently at least for a certain window of time every day. but she still hasn't had that computer, so she hasn't even been able to start whatever research or anything like that she would do, or writings that she was going to do on a laptop yet. She's supposedly going to get it on Monday. She does have access to a tablet, she says, that has very rudimentary law library access in this tablet. The tablet exists primarily, she says, to sell the people staying in jail the right to buy TV shows or movies that they can watch on the tablet. But she says that there's very limited information that she was able to find in this library that is available on, law library, I guess, that's available on her tablet. So I hope that she will also be given additional access to more resources to prepare for this trial if she's not going to have an attorney to represent her. But she does need an attorney who obviously has experience and the resources and the availability to do the case on short notice and to devote a couple of months to prepare for this trial, and that obviously will have access to all the case law, statutes, articles, and all the stuff that you need to properly prepare the case. So that's all that I can discuss as far as my meeting with Sarah Boone. I think that I've seen the evidence before, and definitely I think that one of a kind is a good description for this type of case. I express again my condolences to the loved ones of Jorge Torres. I know that he had daughters that he left behind. And so I'm usually in this channel more focused on the victims' rights and giving the victims a voice. And I think I still would do that on every case, including this one. But this one is a different type of case with a lot of moving parts in it. And obviously, George will never get a chance to give his side of the story. So that is unfortunately true in every case where there is a death. But my personal opinion is that I think that the judge jumped the gun too fast on this issue of forfeiture and waiver of the attorney-client privilege right. I did some research actually about it myself, and I did find case law where it says that there should be an evidentiary hearing where the person who's going to be found to have waived or forfeited her right has an opportunity to respond, right? So in this particular case, what happened was that there was, again, a hearing with Ms. Cashman. I didn't watch any hearing on the motion to withdraw, so I'm not sure if there was a sufficient opportunity for Ms. Boone to respond to the allegations. I don't believe I've seen any hearing of that nature, but if there was one, great, then I guess I'm wrong. I don't remember seeing a mention of an evidentiary hearing in the order that the judge issued making those findings. So bottom line is that she still could have an attorney. What it will take is going to be an attorney who is willing to do this pro bono. And pro bono with the understanding that there are going to be a lot of eyes on the case. So maybe that's a benefit. Of course, it's not a great benefit to an attorney to take a case pro bono on a case where there are going to be a lot of eyes on the case if there's nothing to do. So I think that, I think, I guess it would be more attractive, of course, for such an attorney if there was a winnable defense, if there was a chance at least of prevailing. So I'm not going to give my opinion about whether that's a possibility or not. But I do think that an attorney that still does practice criminal law, that would like to have a case that is unusual, I think that they should give it a shot. And you all know if you're an attorney in Florida and you do criminal defense work, then you know how to set up a meeting. So maybe go meet with her and see if I'm correct, if she was reasonable, and whether she's someone that you could work with. So That's it. I'll answer a few questions about anything other than my communications with Sarah Boone. So if you guys have any questions, go ahead and put them now. Unfortunately, I wasn't reading through the chat because I was busy thinking about what I was going to say to you guys. So hello, everybody. Thanks for being here. Thank you for chatting with each other. So when did I talk? I think I already answered that question, the 29th, 30th, and 31st. 29th was just a few seconds just to make sure that she was willing to talk to me and to explain to her that it was all going to be protected by attorney-client privilege, and I respected that. So I will not discuss or divulge any other details about our communications. So, any other questions? I can't answer things like this because even if I did discuss it, this is all protected by attorney-client privilege. So I appreciate that. So if you have any questions, it will not have to be about my conversations with Ms. Boone. I don't know. Well, there's no question here. All right. So I'll give you guys another minute. If there's any question, I'll respond to it. Any question that I can answer. That's a good question. So can the judge change his mind? Yes, of course the judge can change his mind. It's not a final decision in a sense. I mean, there might have been a right to appeal. By the way, this has become an issue. That's a very good point, and this is something that I do want to discuss, right? So what are the implications of the decision by the judge to allow her to force her to represent herself at the trial? Okay, so to me, this is of course an issue that can be appealed. It might have been possibly appealed before the trial happened, but in all the cases that I've read, it became an issue after the trial happened. And in one of them, it was reversed. So now, because of this decision, now we already have an issue, maybe even a strong appellate issue for Sarah Boone. And what that means is potentially dragging the family of George through one trial, getting potentially a conviction, then the case gets appealed, then she raises an appeal, and by the way, she will probably get appointed an appellate lawyer at that time. Then she raises an appeal the whole issue that she still should have been allowed to have a lawyer represent her, that the judge made an error in finding that she had forfeited her right or waived her right to counsel by her conduct, by not holding a full evidentiary hearing, so on and so forth. So she could make all those arguments on appeal, and if that happens, what would happen is that the conviction would be reversed, case would be sent back, and now she would get appointed an attorney, and then she would have a retrial. And that is not in the interest of justice. And that's why I think it would be great if somebody would take over and defend her for the trial. May still create an issue that could be appealed, but I think that it wouldn't be so prejudicial if you had a very competent attorney who had the resources and the time to do it, to then take over the case. So you may be saving the victim's family from having to go through multiple trials in the case there is a conviction. So, hey Giovanna, nice to see you. No, I'm gonna answer that because it has nothing to do with Sarah Boone. It was something that I decided ahead of time before I even tried to go speak to her, that I could not do that. I'm not going to represent her. I have never done, as a criminal defense attorney, a murder trial. and wouldn't want to be involved in this case because of that, and also because I'm retired from doing criminal defense work for years, and it has never been the focus of my career. My focus has been on civil litigation, not on criminal litigation, although I am a former prosecutor. Hey, Matt, nice to see you, my friend. Any other questions? My pleasure, Giovanna. Hey, Don, nice to see you. Okay, so anyway, I don't see any more questions, so I'm gonna get going. We got plenty of other stuff to do. I'm working on a video for the Denmark Cow murder case, the state of Florida versus Donna Adamson. We'll see if I'll do that today or not, but that's coming up soon. And I also have a lot of materials coming on other cases. So this was a video that I told Ms. Boone that I would do, and I'm doing it. So here we go. I've done it. I'm also going to see if a few young lawyers that I know may have an interest in taking the case. And if you're a lawyer out there, consider that as an option. And I believe that she will be reasonable and she will work with you and will appreciate your efforts. Okay. Thanks everybody for watching. Until next time, and to the lawyer.